Blind SA, through Section 27, is seeking to change copyright laws. This says to help those with visual impairments to better access books. For more on this, we can speak to the University of Stellenbosch's Professor Owen Dean. Prof, a very good evening to you. Welcome to the program. First things first, how is it even that such a loophole exists in our copyright law where people who are blind or visually impaired are unable to access books in Braille as easily as they should?
Well, first of all, let me say good evening to you and your listeners, and thank you for giving me this opportunity to talk to you on this program. The way copyright works is that it gives exclusive rights to the authors of works. The whole object of the exercise is to enable authors to earn a living out of their output. So they can charge royalties for the use of their works, and that gives them an incentive to create works, and it enables them to make a living out of making their works. However, that exclusive right which is given to the copyright owner can impact adversely on the public at large, because obviously they are restricted from using works freely. So a balance has to be achieved between giving the copyright owner his just deserts, enabling him to earn his pound of flesh on the one hand, and on the other hand, looking after the interests of the public. Now, the way in which the law achieves this balance is to create exceptions in deserving circumstances. Now, South Africa is a member of an international treaty called the Berne Convention, which regulates international copyright throughout the world. It lays down the ground rules for copyright, and it sets out circumstances in which exceptions can be granted. And it specifies exceptions in certain respects, and then it gives countries a more general discretion to create additional exceptions if they consider that appropriate. So where we stand at the moment is that our law does make provision for certain exceptions, but it's very difficult for the lawmakers, and bear in mind that our Copyright Act dates from 1978. It's very difficult for lawmakers to envisage every conceivable circumstance in advance when exceptions might be necessary. Now, internationally, a very strong movement has developed in favor of granting the blind exceptions, which will enable them to get more easy access to works in Braille and in other forms which are able to be read or consumed by people with disability.
The issue,
so that is quite a recent development, and South Africa is tuned into that development, and consequently our government has decided that it is necessary and desirable to grant an exception in favor of the blind. The trouble is that this particular exception has become wound up with a whole bunch of changes which the government wants to make to the Copyright Act. Unfortunately...
Prof, let me come in there on the issue of the Copyright Act, because I wanted to ask you about that. One of the issues with this draft currently on the table has to do primarily with the issue of fair use and how that determination is made. Why is that so problematic?
Well, the whole idea is that exceptions should be given in special circumstances. There shouldn't be exceptions across the board. Now, I mentioned that the Berne Convention lays down certain areas where you can grant exceptions, and then it gives a further discretion. But the discretion is subject to a couple of conditions. The one is that they must be exceptional, special circumstances. They must not conflict with the normal exploitation of the work, and they must not cause undue hardship to the copyright owner. Now, if you go too generously with your exceptions, you can fall foul of those conditions. Now, in America, for instance, they have this system which they call fair use, which essentially amounts to judge-made law. The judge in any particular circumstance can decide whether he thinks in a copyright infringement case, the person accused of infringing deserves to be able to make free copies and can then grant an exception. That is something which is peculiar to America. The rest of the world adopts a different approach where the exceptions are more clearly defined in the legislation so that there is certainty. People know where the dividing lines lie. The current amendment, which we're talking about, seeks to introduce this whole concept of fair use into our law, which is an anathema because our law is not geared that way. And there's a lot of opposition to that. I personally think it's a bad idea because it creates wholesale possibilities for exceptions to be given at the drop of the hat at the discretion of a particular judge who happens to be hearing a particular case. It creates uncertainty because nobody knows in advance what exceptions are going to be available. You will only find out at the end of a copyright infringement case, which may have numerous appeals. It may take 4 or 5 years to get to the end of the line, and only then will you know whether there was an exception or not. And that is, to my mind, a very unfavorable and unsatisfactory situation.
And Braille says, so far, pardon me, Prof, we're almost out of time, but I was looking at something that Braille SA had put out saying that they estimate about, Blind SA had said they estimate about 10% of requests to turn these works in order for people who are visually impaired to be able to access books. Only 10% of those requests are actually granted. Why is that?
Well, that deals with a situation when you don't have an exception, where someone wanting to convert a work into Braille or some form accessible to the blind has to go to the copyright owner and ask for a license, and licenses may or may not be granted. But an exception will overrule all of that, and so there is a lot to be said for having an exception and to making these works more freely accessible to the blind. There's pretty well common cause that such an exception should be granted. Where there is dissension is quite how it should happen and the wording of the provisions which will create this exception.
So to your mind, Prof, what would be the perfect text then as far as making sure that the blind are catered for in the copyright space?
Well, I mentioned that giving an exception to the blind is a fairly new development internationally. There is a treaty called the Marrakesh Treaty, named after the city of Marrakesh where the treaty was signed, which seeks to regulate the whole situation internationally. It lays down a very workable solution. It allows copies to be made in favor of the blind in very generous circumstances. It also allows for importation and exportation in between member countries of the treaty so that one can import Braille books, for instance, without having to do the actual work in South Africa. And conversely, South African Braille books can be exported overseas. Now, the ideal situation is to comply completely with this treaty, fall into line with what is the international view, and to comply with the treaty so that we can sign up to the treaty. Now, the problem with what is happening at the moment is that the section of the Act, which is before the Parliament and before the court, doesn't do the job properly. It doesn't fit in with what is required by the treaty, and it's not going to work. And that is a serious problem, and that is what has given rise to this court case brought by Rule 27.
Thank you very much for that, Prof. Owen Dean speaking to us tonight on the program from Cape Town.